Today's webinar is entitled Pharmacy Strategies to Limit Business Disruption from Suspicious Order Monitoring. Today's speakers include Friar LLP partner Anthony Mahajan, who chairs the firm's white collar defense and government investigations practice, and Stephen Bennett, who is a partner in the firm's pharmacy practice group. Before we get started today, I just wanted to note that all lines have been muted. I also want to remind you about the Q&A tab on the bottom of your screen. Please feel free to type in your questions throughout the webinar today, and we will wait until the end of the webinar to answer those, but we'll be sure to get to all of them, whether it's during the live webinar now or in an email to you following today's presentation. Just so you know, this webinar is also being recorded and will be sent to you so that you can watch it again in case you missed anything, and that you can share it with any of your colleagues who you think may benefit. So without further ado, I am pleased to turn this program over to Mr. Mahajan.
Thank you, Lauren. Hello, everyone, and good afternoon. Happy Friday to all of you who've joined us. My name is Anthony Mahajan, and together with my partner, Stephen Bennett, we hope that you find today's presentation useful in developing business strategies around your controlled substance obligations. Before we dive into the substance, please understand that today's presentation is provided for informational purposes only and does not constitute legal advice and is not provided in the context of an attorney-client relationship. Although obviously we have that relationship with many of you, today's presentation involves the provision of business advice and business advice around the legal framework in this area. So in the event that you should seek legal advice about any of the matters discussed today, we'd ask that you follow up with us in a separate conversation. Just a little bit about the firm. As most of you probably know, Friar LLP is a full-service national law firm that is laser-focused in the healthcare space. We advise participants throughout the healthcare supply chain, as well as life sciences companies, including large corporate entities and executives, with respect to everything from M&A, litigation, regulatory counseling, compliance program maturation, and white-collar defense. Our headquarters are located in New York and New Jersey, but we service clients around the country. So please call on us if you're in town. And as someone who is presently commuting into our New York City office, I'm pleased to report that the numbers of people commuting and on public transportation and driving into New York City, we're down by the World Trade Center, have increased each week. So that's good to see. Next slide, Steve. So just a little bit about a background on myself and Stephen. But before we talk about ourselves, I just want to acknowledge all of you, the folks who have joined us today and are attending today's presentation, consisting of pharmacies of all types, distributors, technology companies, educational and research institutions, hospitals, and healthcare practitioners. You are an incredibly diverse group, but each and every one of you has contributed in your own way towards helping this great nation move past the challenges we've faced for nearly 18 months now. So we at Friar LLP cannot thank you enough for those incredible efforts and your contributions. As Lauren mentioned, my name's Anthony Mahajan. I'm the chair of Friar LLP's White Collar Defense and Government Investigations Practice Group, where I assist corporate entities and individuals who are dealing with some very acute situations involving government enforcement, including criminal charges, across a wide variety of healthcare subjects. If you're interested in our group's practice more broadly, you can visit the website. There's a link there. But with respect to today's presentation and controlled substances in particular, I was fortunate to have the opportunity to work for the Department of Justice for nearly 10 years, where I investigated and prosecuted controlled substance offenses against a number of entities and individuals. In that capacity, I came to understand how some of the larger distributors and manufacturers administered their controlled substance obligations through suspicious order monitoring programs. And so after working for the government, I was recruited by McKesson to oversee and to assist with the company's compliance at the corporate level with a 2017 settlement and compliance addendum with the Department of Justice and DEA. In that capacity, I also counseled McKesson's businesses as their DEA obligations more generally, including importation and contract manufacturing. Finally, after leaving McKesson, I served as the Chief Compliance and Ethics Officer for United Health Group, which is a diversified healthcare company. It's a sprawling enterprise, $250 billion in revenue, and nearly 330,000 employees. In that capacity, obviously, my role was broad, but I assisted one of the businesses, I'm sure you're all familiar with, Optum RX, with respect to the preparation for a Medicare audit and claims edits around controlled substances. So that's a little bit about my background. I'm joined today by my partner, Stephen Bennett. Stephen, could you please introduce yourself?
Yeah, of course. Welcome, everyone. I've spoken with a number of you all who are on the presentation, in our own separate matters. I've been with Friar Levitt since 2013, representing mainly providers in the pharmacy and drug reimbursement space, focusing a lot on our specialty pharmacy clients, their needs. I've seen a lot on how the changing world and regulation around opioid dispensing has changed over the last 7+ years, and being able to advise clients both on active litigations that they're in, both prosecuting and defending them, as well as avoiding litigation risk. Before I was at Friar Levitt, I spent 4 years at the New Jersey Office of the Attorney General as a prosecutor. I prosecuted criminal insurance fraud for 3 years, and then I was in the gangs and organized crime division for 1 year before that. So welcome, everyone, and we look forward to sharing the information today.
So here's the agenda for today's presentation. Before we talk about strategies that you could implement in your business, I wanted to make sure that we are all level set and have a common understanding of the obligations at issue and how those obligations are continuing to evolve in recent legislation proposed by the DEA. In many ways, in fact, understanding the state of play today is in itself a business strategy, because there is often confusion and lack of insight as to why an order is canceled, not shipped, why an order is rejected. And in that capacity, distributors are often hesitant to provide customers with much clarity around their suspicious order monitoring systems out of a concern that someone could use that knowledge to so-called game the system. I don't think that's terribly realistic given the sophisticated nature of some of the modern day systems. But my hope is that if nothing more, you will leave today's presentation with a full appreciation of the obligations imposed on the relevant participants throughout the supply chain. And in turn, that understanding will help you develop your own tailored business strategies and approaches to controlled substance distribution. So we're going to talk about the obligations. We're going to talk about how these programs have evolved, how they're continuing to evolve, the evolution of this so-called due diligence, a very illusory standard, not really captured in the statutes, but the subject of informal promulgations by DEA, and maybe more recently in the proposed rule, some standardized rulemaking there. And finally, then we'll get to the strategies that you can use each day in your businesses. So just starting at the top of the supply chain, the obligations imposed on manufacturers largely mirror those imposed on distributors. Both types of registrants are obligated by federal law to kind of comply, and this is the touchstone in the law, to maintain effective controls against diversion of controlled substances. So the maintenance of effective controls is essentially the phrase that's used in all of DEA's rulemaking. And that phrase has been defined more broadly in recent times. It's separate in itself from the requirements that are imposed by statute in the CFR and the DEA rules that range from where you need to place your camera in a cage and how to maintain security and access to controlled substances. So in that capacity, manufacturers and distributors, as relevant here, we're not going to talk about obligations other than those that pertain to suspicious order monitoring and controlled substance ordering. Automated reports and consolidated ordering system. I'm sure you've all heard of it. It requires manufacturers and distributors to report to DEA all Schedule 1 and 2 sales and certain other Schedule 3 and 4 sales. That goes to headquarters at DEA, to a specialized unit that, in contrast to how DEA has handled suspicious orders, actually has provided a lot of assistance to the DEA units and investigators in the field. This unit is able to slice and dice the data in a very tailored way and can provide some detailed benchmarking across pharmacies and geographies. Now, more recently, the DEA has responded to some of the concerns and complaints from distributors that were operating these suspicious order monitoring programs, that they did not have full insight into what their customers were ordering, because they did not know if they were the only wholesaler servicing the account. And so all of those concerns, not necessarily kind of that probative in all cases, because oftentimes the distributors required dispensing reports, but those were not necessarily done on an updated basis, and they're sometimes hard to analyze. So in any event, at this point, now DEA has offered distributors a tool that will allow them, in connection with their due diligence obligations, to query a particular drug code to see, for a prospective customer, that's the language of the statute, but a prospective customer likely includes a prospective order, so current customers can be queried as well within the statute. So that allows the distributor to view the total number of distributors and the amount of a controlled substance that was sold to that customer over the last 6 months. Moving on to the suspicious order reporting obligations, which are separate from the ARCO's reports, obviously. I've included here the statutory language. We're going to talk in depth about what this means and how systems have evolved to address the language that requires reporting of orders of unusual size, deviating from a normal pattern, and of unusual frequency. And then finally, as I mentioned, we'll talk about the due diligence requirement. You should know that in the statutes, there is only one requirement, and that is to make a good faith inquiry into whether the person receiving the controlled substance possesses a DEA registration that would permit that person to possess the substance and class of substance at issue. However, the DEA, as I mentioned earlier, has expanded on this requirement, and we're going to talk about that shortly. So just kind of moving down from the manufacturers and dispensers quickly here. So pharmacists and practitioners have obligations with respect to controlled substances that are obviously distinct from those upstream entities. Let's just start at the bottom of the slide with respect to the prescribers. The law requires that a prescription be issued for a legitimate medical purpose within the usual course of professional practice. And that sounds quite simple when you read it, but it's anything from anything but simple. So, for example, there are very difficult questions that arise when, for example, a drug-seeking patient presents in parallel to treatment for an underlying medical condition. Let's be very clear here. The medications at issue, although they've been vilified out there in the public, have helped millions of patients maintain a better quality and function in life. But at the same time, they're classified as controlled substances because of their potentially addictive qualities and the potential for abuse. So as for these practitioners, they have a very difficult balancing act to do. That is between treating legitimate medical conditions with substances that are addictive in nature and subject to abuse. So therefore, the kind of delicate monitoring and follow-up and considerations around titration are kind of present within this seemingly simple definition of what's required for a prescription. That's in fact a discussion for an entirely separate webinar. As to pharmacists, they have the corresponding responsibility to see to it that the prescription they are filling complies with the law. So accordingly, if there's circumstances surrounding the presentation of a prescription that should raise a reasonable suspicion as to the validity of that, these so-called red flags, there may be an obligation to look further to see if those circumstances can be resolved for legitimate reasons. You don't want to kind of turn a blind eye, because that's equally troubling. Among other things, they may involve validating the prescription with the physician, checking the PDMP, or otherwise using your common sense and judgment to determine if it's a prescription that is appropriately filled in your common sense and judgment. Steve, you can move. So just with respect to how did we get to the point we are at today with respect to the reporting of suspicious orders, the earliest cases involved essentially barrels of precursor chemicals that came over actually from foreign countries like China that were actually either used in methamphetamine manufacturing, or were sent down to Mexico and kind of used for laboratories down there. It's not a new requirement, but since 2007, the DEA has placed a renewed emphasis on this regulatory requirement. And at that point, in 2007, you have to understand that the DEA was confronted with an alarming rise of internet pharmacies, many without even storefronts, that were filling prescriptions written by physicians located hundreds of miles from their patients. The quantities at issue were pretty high. In fact, they were, on their face, pretty extraordinary. And many of the prescriptions at issue were written by practitioners who were located far from their patients and who had not done actual physical consultations. And so therefore, the DEA took the position, because there existed no bona fide doctor-patient relationship, that this constituted diversion. And that formed the basis for a series of settlements in or around 2007 and 2008 with some of the major wholesalers, in which the DEA took the position, although they were dealing with diversion, they took the position that these distributors were required to report so-called suspicious orders, irrespective of whether the customer was actually suspicious, or irrespective of whether there were circumstances indicative of diversion. And so around this time, the wholesalers essentially started implementing a number of systems that all, although they varied in nuanced ways, they all used what's known as a threshold, which is the upper limit for a customer's purchasing of a particular drug family, oxycodone, hydrocodone. There were some that permitted a deviation above that threshold for known customers and for various circumstances such as discount buys. But the way they worked was essentially to have a very static and fixed limit. These days, however, the distributors have implemented far more sophisticated systems. And as you can see from the 2017 McKesson settlement, they are using dynamic thresholds that change from time to time, whether that be month to quarter, that take into account customer-specific data and benchmark data, not only for those types of customers, but for customers of similar size or similar class in similar geographies. Steve, you can move to the next slide. So just to kind of hit quickly on the proposed DEA rule, the DEA has promulgated a notice of proposed rulemaking that adds another option to the reporting of a suspicious order, and that being a distributor does not need to necessarily deny a flagged order as suspicious if it's over a threshold. In contrast, now under the proposed rule, distributors have the option to further investigate. And I think the standards around that investigation will make it more likely that distributors will simply report the flagged order than actually conduct an investigation. But there may be times in which an investigation is warranted. However, the standard is quite subjective as the rule currently stands. It requires that the distributor identify and clear essentially circumstances indicative of whether a person is engaged in or is likely to engage in the diversion of controlled substances. And obviously that's a very arbitrary standard. I believe that based on the way DEA has enforced the statute in the past, I think distributors will likely err on the side of systems that potentially over-report suspicious orders, given that they've been penalized for under-reporting in the past, and will likely not kind of get involved in factual inquiries into their customers that have the potential to further subject them, if down the road there's a problem with the customer, to claims that the distributor knew about what was going on and kind of turned its back. So more to come on this. I don't know how this will come out. I don't really think it will actually make a difference. I think the distributors will stick with the systems they've implemented. They have invested lots of time and money into these systems. They're sophisticated, they're dynamic, they meet customer needs in most instances, and investigations into people and determining whether they're likely to engage in or have the potential to engage in diversion are just untethered to any concrete standards and pose a risk in themselves. Next slide, Steve. Steve?
Are you seeing the next slide? I have it up on my end.
Okay, that's fine. There we go. Okay, so just with respect to the due diligence obligations, as I mentioned, there's no due diligence statutory requirement. It ties back to the requirement that registrants maintain effective controls against diversion. However, around the time of the distributor initiative, the DEA promulgated some informal guidance via letters to the industry by their deputy administrator at the time, setting forth some of the questions that registrants should ask themselves. And this is not specific to distributors, but also applies to pharmacies in terms of considering how regulators will look at particular business. The questions that are articulated here are relevant. And, you know, even though they were first articulated back in 2007, they are kind of equally relevant today. And they're not only, I should note, they're not only necessarily relevant with respect to controlled substances, but we see regulators kind of asking these questions with respect to medications more broadly. So what percentage of the pharmacy's business? There's, you know, benchmarks in the industry. The accepted standards are 15 to 25% on the upper end of controls versus non-controls. With respect to the shipping, you could see that that's something that applies beyond controlled substances. We're seeing a lot of investigations into pharmacies where there's shipment across state lines or into areas where pharmacies are not registered. You see there's some focus on online applications and questionnaires, as well as questions about the prescribing practitioners, which historically has been a question that both distributors and DEA have asked. Some distributors pose it in terms of who are your 5 highest prescribers, and they'll then seek to conduct due diligence themselves into the disciplinary background of those prescribers, as well as the practice characteristics. So that's always been something that has been a focus for regulators. Okay, we can move on, Steve.
Great, we're on the next slide.
From 2007, the obligations have evolved. Some of the more recent sources for what DEA will claim are obligations on the industry come from a decision in Masters Pharmaceutical Inc., as well as the congressional report by the Energy and Commerce Committee. So there were some recommendations in that report that everyone should familiarize themselves with, because these are the types of questions and the types of documents and the types of investigations that regulators will be looking for when they scrutinize distributors and pharmacies and practitioners' files for compliance to controlled substance obligations. So you see the reference to red flags, due diligence, documentation, maintenance of updated information regarding your customers. In many ways, the controlled substance due diligence obligation is similar to the so-called KYC obligation in banking, to know your customer, right? So there should be an investigation at the beginning of the relationship, as well as updated touch points throughout, is what, you know, DEA and regulators have said are the kind of guideposts. Next slide, Steve.
Yep, here we go.
So the proposed rule here, I think I've covered a lot of the comments with respect to the types of investigations that DEA is seeking to impose on distributors. I think it's relevant for our pharmacy attendees to look at, because when the distributors come asking reams of questions with reams of paperwork, the reason that they are doing so is that they are satisfying their obligations and the expectation DEA has placed upon them to essentially serve as the so-called choke point for the flow of these substances and to prevent diversion, because obviously DEA can't regulate and it does not have the resources to inspect each and every registrant under the code. So they use the distributors as the checkpoint. And that's why as DEA increases pressure and regulation on the distributors, that in turn will be felt downstream by registrants, including pharmacies and practitioners. So the obligation the DEA is seeking to impose with respect to due diligence means a very onerous standard, reasonable and documented investigation, including an examination of each suspicious circumstance surrounding an order to cover relevant indicators of diversion in terms of trying to determine whether a person is engaged in or is likely to engage in the diversion of controlled substances. I think this is aspirational for the DEA. I don't understand how they can expect distributors to kind of make this analysis, especially with the limited insight distributors have into their customers. And when DEA has such trouble doing it and bringing cases involving diversion against pharmacies, given all the resources, including law enforcement, cooperating witnesses, wiretaps, and the like. So, the indicators of diversion are not what we've seen in the past in 2007. It's not numbers anymore. They're far more nuanced. And I don't think anyone has a real good handle on what could be indicators of diversion. We see suspicious flags and circumstances, but that doesn't in itself indicate that diversion is going on. So we'll see how DEA moves forward with this rule. But the broader point here is that they are expecting more of distributors, and they're going to in turn be expecting more of pharmacies. So we'll talk about how to address some of that increased scrutiny. Next slide, Steve. So just in terms of the environment here, I wanted to just kind of give you a sense of what we at Friar Levitt have seen. Because we service clients all across the country, we're able to observe trends in a number of different areas, and we have indeed observed a significant ramping of enforcement and focus on controlled substances. I don't think anything that I'm saying comes as a surprise to any of you, because the public outcry in response to the epidemic has been robust for sure, and you can expect that law enforcement will respond in turn. So I just want to take a minute to outline the different types of inquiries and personnel that one might encounter in this space. You are all obviously familiar with the DEA, but what you might not realize is that there are a number of different components within DEA itself that are involved in investigations and prosecutions. So in your first instance, you have the DEA agents that classically have been those investigators who are focused on the interdiction of street-level drugs like cocaine and heroin, and more so in recent years now focusing on controlled substances. If charges or if there's an investigation by DEA agents, they more likely will result in criminal charges as opposed to the other type of personnel that are present alongside DEA agents in the field offices. And by that I'm referring to the diversion investigators. And so the diversion investigators are not agents. They are personnel that sit in the field offices in the states with the DEA agents. They are the ones responsible for coming out and checking compliance. They do the cyclical investigations and audits. They check compliance to the CFR regulations. And in years past, they were kind of more focused on, are the security conditions met? Is there a list of people who have access to the cage? However, now what we've seen is that the DEA is doing a far better job of combining these resources and using the specialized expertise of the diversion investigators who have visited their customers, the pharmacies and distributors, visited not their customers, but the pharmacies and distributors in their area. They are responsible for inspecting. Combining those people with the DEA agents, and also kind of seizing resources from willing state agencies who are all the more willing to contribute to the task force with state police or county police. And the incentive there is that if there's a seizure or a forfeiture, the state or county will get a piece of that back for the officer that had been assigned to the task force. And finally, within DEA, there's also the Office of Diversion Control that exists at headquarters. And the enforcement actions that are brought by that office, although less in more recent years, have been those ISOs, the immediate suspension orders, the shutting down of distribution centers in various locations. So, certainly across the board with law enforcement, they're doing a better job kind of combining resources. There's a renewed emphasis there. There's a number of constituents that have obviously contributed to the effort, whether that be state or federal politicians and governments. And so that is contributing to obviously, an increased enforcement trend. As for private litigants, there's been some developments in the courts that make it easier for litigants to bring claims under the False Claims Act. So for example, the PDE records, the prescription drug events claim, those are being utilized as, and courts have held that they constitute claims in and of themselves, even though nothing's false in them, if they are the result, or if they reflect transactions that are the result of unlawful activity. Private litigants are adding pharmacies and distributors on that basis. Finally, with respect to the BOP administrative authorities, we're obviously seeing more focus there. And one of the things that I think is interesting is that while classically things like inventory shortages, regulatory violations have been kind of addressed at that level, I've recently seen cases where the federal authorities have charged inventory shortages under 21 U.S. Code 843, and I had to look up the provision because it had never come to my attention back when I was a federal prosecutor. But certainly now, even inventory shortages could lead to federal criminal charges. So, Steve, you can move forward, and I'll hand off to you for the remaining slides.
Thank you. Just picking up where you left off, inventory shortages, we've been seeing more and more pharmacy benefit managers or PBMs reporting inventory shortages and really other audit results that they're finding in their private contract enforcement up to state and possible federal entities that could lead to other enforcement action as well. As far as strategies that a pharmacy provider can use to kind of limit the business interruption of suspicious order monitoring, I think the top and foremost of them is to communicate with your wholesalers and who you're purchasing product for business attributes about the pharmacy or the provider that could make your purchasing records otherwise, show a red flag in the system. So you have many times where a pharmacy or a hospital, in a hospital a pharmacy in a hospital setting, for example, will be purchasing products that look different from the average of the normal pharmacy. And so that difference in business operations is really what could drive purchasing records that deviate from the national norm that a wholesaler might have finely in tune. So it's really important to communicate with your wholesaler about that. You might have a pharmacy that is located in the same physical location as a pain management clinic, a pharmacy that is part of a physician dispensing. We're closely partnered with a physician dispensing, where you might be dealing more with cancer patients, dealing either with normal cancer-related pain or even breakthrough cancer pain that could lead to increased purchases of products that otherwise could trigger suspicious order monitoring review by wholesalers that could really be minimized if you are communicating it. And it goes along with something else we'll be talking about, which is having compliance programs in place. That communication, it's not just communicating about what your purchase patterns are that might deviate from the norm, but it's also likely having in a policy and procedure about these purchasing that could alleviate any otherwise legitimate concern from the wholesalers. Also, just understanding that there might be different purchasing patterns by time of year, by volume for discount. All these things could be communicated to wholesalers to minimize the impact. That leads to the next point, inventory management. Understanding that there are a lot of providers that purchase in bulk to receive discounts in anticipation of rising prices, or just as regular inventory replenishment. If there's an episode like that, to communicate it, and you might even set in place, instead of purchasing in bulk and less periodic, instead set up an automatic replacement where you're purchasing at very consistent levels across the board. Understanding that it does happen that you purchase in bulk, but an adjustment replacement program with your wholesaler might not then trigger suspicious order monitoring review. There's also the ability to some extent, diversify your acquisition sources. Obviously, a lot of pharmacies have prime vendor agreements where you're required to purchase a certain volume of product from a single wholesaler. You could still diversify some of your purchasing through licensed secondary wholesalers, understanding that the market isn't necessarily just one provider. There are other relationships you could get for sourcing product, including directly from manufacturer. And there's also, in limited circumstances, pharmacy to pharmacy transactions. I would say that depending on what entity you're concerned about reviewing pharmacy purchases, there's different risks that are associated with each one. There's pharmacies, in the news, most of you probably have heard about relationships direct with the manufacturer that could lead to scrutiny. Purchasing, you'll see stories about purchasing from secondary wholesalers that maybe weren't appropriately credentialed or licensed, that could lead to issues both publicly and privately. And with any pharmacy to pharmacy transactions, make sure you're complying with the appropriate state and local laws, and importantly, documenting any of those kind of alternative diversification in acquisition methodologies. If you're purchasing from a pharmacy, really any product, it's most important to have documentation regarding that transfer, following pedigree requirements as it applies, and then having a bona fide financial transaction that goes along with it. Other strategies is that you could also onboard with a buying group, a entity that their interests are a little more aligned with the pharmacy provider in actually buying product through them. A lot of buying groups have members where they are partial owners of the buying group, and also the buying group in general benefits from when purchases go through them, because typically they'll pass along those bulk savings from the larger buying group acquisition from the drug manufacturers. Also, it's important to understand you may have a prime vendor agreement with any particular wholesaler, but it's important to periodically evaluate whether that best suits your needs. Are there other agreements that are more beneficial? Is there a natural termination or renewal time periods where these things should be reviewed? And then, as I mentioned earlier, it's very important to have a compliance program implemented in the pharmacy regarding opioid purchases, controlled substance purchases, storage. All of these things have a lot more scrutiny now than they might have had many years ago, and include not just having the documentation, but reviewing them periodically, updating them, and most importantly, following them. If all you have is a policy and procedure written down, but you don't follow it, the shield or the protection that a policy might have could actually be turned into a detriment. If it turns out you weren't following your policy, It actually looks worse if you had a policy but you weren't following it, versus you had a policy that you periodically review, perhaps with an attorney, that you were following. Then you could say, we had systems in place, or we have systems in place to avoid this. And that includes both understanding requirements under the law, but also satisfying different responsibility, making sure you are appropriately reviewing prescriber information, customer information. They could be detailed compliance programs that would protect you in circumstances not only from suspicious order monitoring, but could catch an issue before it actually becomes a problem in other circumstances, such as relationships with pharmacy benefit managers or scrutiny by federal and state and local enforcement agencies.
Right, let me add a last point a little bit harder, Steve, there. I mean, just think about kind of in terms of answering questions that are seeking to probe why certain orders have been made at the pharmacy level. If you were able to provide the distributor or manufacturer even with a very nicely bound, fully articulated set of policies and procedures that not only addressed your business operations, but also demonstrated the steps that you take to conduct due diligence on your customers, the prescribers as well. In other words, so if you have your top 5 prescribers, if you've gone to them, if you know that they implement pain management contracts, if you know that they kind of conduct regular urinalysis, if you know that they require their patients to use a particular pharmacy so that PDPMP data is accurate, those are all the types of details that a wholesaler will look at and feel more comfortable servicing your specific needs, whether they be in line or slightly above or even a lot above other similarly situated customers, because the wholesaler will be able to rely on the fact that you have implemented a very robust and effective compliance program. So the overall message there is help them meet their obligation. That helps you with your business.
I agree with all that. So we've, I think we're actually exhausted the time a little bit over. We do have some questions. I think what's most appropriate for everyone's time is we could follow up individually with those open questions. And we could get back to you. If you have any questions, of course, we could continue the conversation directly. You could feel free to email Anthony or myself, or fill out even just an inquiry on our website. Of course, if you deal with another Friar Levitt attorney, feel free to reach out to them as well. Anthony, anything to wrap it up?
No, thank you, everyone. Really appreciate your attention.
Thank you.